we're going to be getting very geeky, super inside, detailed information about the Rahimi Supreme Court case. You're not going to want to miss what's coming up over the next many weeks. Here is where we're going to begin, though. I'm going to start to show that Merrick Garland, the Department of Justice, and the Biden administration have tremendously exaggerated the public safety component and importance of 18 U.S.C. 922 G8, which is the relevant section of the relevant statute that is at issue in the United States versus Rahimi case. You will be shocked at what has been uncovered with what we're going to talk about in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the book, First They Came for the Gun Owners, the detailed guide as to how the anti-gunners intend to disarm us in America and take away our freedoms. Check it out if you don't already own a copy. And if you own a copy, I'd appreciate it if you could do a review on Amazon. It helps us spread the word of my Second Amendment work across the globe. All right, folks. So, we need to talk a lot about this United States versus Rahimi case, and we're going to do that in extreme detail over the next many weeks, probably even the next many months. I want to start off with one overall observation, which is what I consider to be the extreme exaggeration, hyperbole, by the Department of Justice and their little gun control friends, who are trying to say that if the gun control law at issue in the United States versus Rahimi case before the U.S. Supreme Court is somehow struck down, there will be bodies piling up on the streets of America. It is simply not true. To begin with, let's just remind you what Rahimi is about. Mr. Rahimi was subject to a domestic restraining order out of Texas. He agreed to this. This is important. There was no trial, there was no hearing to speak of that I can tell. What happened was Mr. Rahimi's, I believe, ex-girlfriend or girlfriend, whatever she was, some relationship in that sense. I think they shared a kid together. He allegedly did bad things to her. She brought a request for a restraining order to say, stay away from me. You've done bad things to me. You've done domestic violence to me. We don't need to get into the details in this video. It's not necessary for this purpose. And he agreed to the entry of this restraining order. Now, that's important because it arguably suggests that he has waived any due process arguments, which will be important potentially in this case. But he basically agreed to the entry of this restraining order. As part of the state restraining order in Texas, he also agreed that he would give up any firearms and he would not possess them. Again, he agreed to it. He consented to it. Now, he did not have an attorney advising him, but this is a civil case. And because it's a civil case, he had no constitutional right to an attorney, and he did not seek one out. Apparently, he didn't have one, and this is what he consented to. But he did consent to it, which goes back to the idea of that I've talked about before in the context of, for example, the Fourth Amendment's right to be free from unreasonable searches and seizures. If a police officer breaks into your car illegally and steals the secret document out of the attaché case locked in your trunk, right? The locked attaché case and a locked trunk and a locked car. Well, there may be a Fourth Amendment problem that says you're not subject to, a warrantless search, you're not subject to unreasonable searches and seizures and so on. But if you say to the police officer in that instance, here are the keys to the car, here's the keys to the attaché case, here's the keys to my trunk, go ahead, Officer Bob, check it out. Well, you basically have waived your Fourth Amendment rights. So the question is going to occur in this Rahimi case as to whether or not he basically waived certain due process rights. I think that issue could come up here because he just says, hey, enter the restraining order. Now, with that said, after that occurred, he was then caught in possession of a firearm, which violates a federal statute, 18 U.S.C. 922 G8. 922 G8 says that if you are subject to a domestic violence restraining order, you are not allowed to have a gun in your possession during the time that restraining order is in effect. Mr. Rahimi was caught with a firearm after the entry of this restraining order and before it expired, which meant that during the time of this restraining order entered by the Texas state system, the Texas state judge, he was caught with a firearm. This triggered a federal crime, allegedly, because again, he was not supposed to have that gun under federal law because 18 U.S.C. 922 G8 says that if you're subject to these domestic violence restraining orders, you can't have a gun under federal law, even if the restraining order is based, of course, in state law. So Mr. Rahimi was indicted and ultimately convicted, but he asserted his Second Amendment defense to say that the Congress, that this 18 U.S.C. 922 G8 violates the Second Amendment. There's no historical analog to justify this. And the Fifth Circuit Court of Appeals down there in Texas, Louisiana, and Mississippi, those are the three states that the Fifth Circuit covers, said that, yeah, there's no this violates his Second Amendment rights. If he gets a murder, rape, or robbery, you can lock him up and take his guns away that way by locking him up in prison. You can always do that. Yes, of course. But the way this specifically is designed, it says if you're subject to a civil restraining order, that alone is just not enough to take away the Second Amendment rights. There's no historical analog, and thus it violates the Bruin methodology, and therefore that statute, or that part of that statute, is struck down. Now, I just want to remind you of one thing, that 922G is also the whole list of what are known as prohibited people, which includes felons, people that are dishonorably discharged from the military, illegal aliens, and so on and so on. This is in that list of prohibited people, of people who, if you're on that list, you cannot possess. You cannot possess a firearm under that federal statute. So again, the Fifth Circuit declared that that one provision of 18 U.S.C. 922G is unconstitutional, specifically 922G8, dealing with domestic violence restraining orders. And as soon as this occurred, Merrick, Garland, and the Department of Justice for Joe Biden raced to the Supreme Court with their hair on fire. Ooh, ooh, this is so terrible. There's going to be all these dead people and all this terrible stuff's going to occur if this law is not, brought back to life. This is so important to public safety, so important to America. But is it? Well, I did a little bit of digging, and it turns out that that's a lot of hyperbole. Why do I say that? Well, let's just look at the data. It turns out, from the publicly available information, which I will put links to the relevant stuff down below. Ready for this? During the time period of 2013 through 2017, that's a 5-year period. 5-year period. How many people were convicted in America, which has 320 million Americans or something like that? 300 plus million people live in this country. So in that 5-year period of 2013 through 2017, how many people were convicted of violating this mission-critical law that's so important to America? This gun control law, 18 U.S.C. 922 G8. How many? 121. Did you hear what I just said? Over a 5-year period, in a country of 300 million Americans, 121 people were convicted of this particular statute, which means that you have 24 people a year in America convicted under the statute. That is less than one person per state convicted of violating this federal statute, 18 U.S.C. 922 G8. Less than one person per state every year is convicted. Nevertheless, because Merrick Garland is hoping to embarrass, intimidate, browbeat, whatever you want to say, the U.S. Supreme Court into ignoring the Second Amendment, ignoring the precedent set by Nysurpa versus Bruin and the Heller decision. Merrick Garland wants to frame this in the public eye as if the Supreme Court that wants to uphold and has been upholding the Constitution as written and understood and interpreted by our founding fathers. He wants to try to embarrass the Supreme Court by saying they are anti-women and that this court doesn't care about women or their lives. This court doesn't care if women are beat up or that anyone is beat up, not just women. It doesn't have to be women. It could be a man. Anyone. Basically, he is going to argue that this Supreme Court, to uphold the Constitution, is essentially siding with evil, domestic, violent individuals and wife and spouse abusers. which obviously is not true by applying the Second Amendment, because if you actually are a domestic violator, a domestic violent violator, you actually have beat up your spouse or a child, you are a criminal. But you're a criminal because you have committed battery, you've committed robbery, you've committed murder, you've committed assault, you've committed a substantive crime by engaging in a violent act which gets you put in prison. So what is the point of this federal law? The truth is this federal law is meaningless. It is a virtue signaling tool that allowed Congress many years ago to say, oh yeah, we're doing something about domestic violence and battered women and so on, which is admirable. It is obviously admirable to try to nip that in the bud. But the truth is this is about state and local policing that deals with these localized neighborhood issues. This is really not what Congress is supposed to be about. This is supposed to be dealt with at the local level by local police officers, local courts, local judges, people in the neighborhood that have a sense of what's happening in a family, with an individual, within that community. It's about local government and local policing, not Congress kind of, govern on high, something that obviously is about virtue signaling. And we know that because it's never used. To give you another bit of data, during the 24-year period of 1999 through 2022, how many people were convicted under this 922G8? 707 were sentenced, according to the data I'll link to down below from the federal government. 707 in a 24-year period all across the United States, which has over 300 million people living here. That averages approximately 30 people a year. 30 people a year were sentenced for violating 922G8 during that 24-year period. So we're literally talking about two dozen people that are impacted by this law. So what possible benefit could there be from having this law on the books? The answer is none. Because again, if you've committed domestic violence, if you punched someone that you should not have, if you've violently done something terrible to someone without their consent and so on, you have committed a crime, a violent crime that you go to jail for. That's the key, right? And of course, Merrick Garland is going to try to undercut these kinds of statistics. Now, some of the language that Merrick Garland has talked about, just to give you a sense of some of his hyperbole, and I'm going to quote from the brief by Mr. Rahimi's lawyer in one of the briefs he submitted to the Supreme Court to try to prevent this from being granted cert. Here is what he writes, quote, given the federal government petitions, this is Merrick Garland's, given Merrick Garland's warnings of, quote, exceptional importance, quote, significant disruptive consequences, and, quote, tens of millions of Americans touched by domestic violence at some point during their lives, and so on and so on. Do you see some of this? These assertions about tens of millions of Americans, significant, exceptional, exceptionally important, all this hyperbole is about trying to suggest this law really matters to public safety. But again, it doesn't. And if it really, really mattered to public safety, it would be used a lot more than a couple dozen times a year. In contrast, by the way, to something that does impact public safety, that Merrick Garland specifically chose not to rush to the front of the line, was the other part of 18 U.S.C. 922G, which is 922G1, dealing with felons in possession. As you recall, there was another Court of Appeals case decided that said that Brian Range, in the Third Circuit Court of Appeals out in New Jersey and Pennsylvania and Delaware, that Brian Range, a nonviolent individual who was convicted 20 years ago, I believe, of some sort of welfare-related fraud of failing to disclose lawnmower income or something like that. No violent incidents in his entire life. And the Third Circuit says that under 18 U.S.C. 922G1, he could not be deprived of his gun rights for life. The Second Amendment would not allow it. Now, that case was available for Merrick Garland to seek certiorari to the U.S. Supreme Court. Same general statute, 922G. So why did Merrick Garland want to rush off and seek certiorari again with 922G8 dealing with domestic violence restraining orders, rather than taking on the most important issue dealing with 922G, which is 922G1. Now, just to give you a compare and contrast of the numbers, do you know how many convictions in the 5-year period between 2013 and 2017 there were for a violation of 922G1? During that 5-year period, there were almost 27,000 convictions based on felon status. 26,717 in the period of 2013 to 2017, according to the reporting. You hear what I just said? You have 121 convictions under 922G8 during the same 5-year period, 2013 to 2017, where you have almost 27,000 convictions of felons in possession of handguns. Merrick Garland could have either sought certiorari from the Third Circuit range case that dealt with those 27,000 cases a year, or in that 5-year window, I should say, that 5-year window. He could have dealt with 922G1 out of the Third Circuit. It was available. The range case was decided by the en banc Third Circuit. Did Merrick Garland go down that path? No, he wants to talk about the basically never used 922G8 coming out of the Fifth Circuit. Why? Because he's trying to browbeat and intimidate with bad public relations the Supreme Court for doing its job. Because he's going to try to say, and the Department of Justice, the Biden administration, and the anti-gun supporting media is going to do nothing but this Supreme Court is going to stand up and support abusers of women, stand up and support domestic violent people that engage in domestic violence, because this Supreme Court hates women. You can see the headlines now, right? That is why Merrick Garland rushed the Rahimi case to the front of the line and has still to this moment not sought certiorari to the range case, even though the range case presents a critical law being dealt with, 922G1, where you have 27,000 convictions over a 5-year period versus the never or virtually never used 922G8. So again, when you look at this Rahimi case and we start really breaking this down in extreme detail, it is mission critical for you to understand what's really going on here. This has nothing to do with public safety because this law is basically never used in this country for all intents and purposes. And that's the dynamic, folks. This Department of Justice wants to put the Supreme Court in a Hobson's choice where they either uphold the Second Amendment and do what they should do under the law, or face a situation where the Supreme Court is going to get hammered by the anti-Supreme Court press, and they're only anti-Supreme Court because they don't control the Supreme Court the way they did for decades, and they're upset about that. So that is really what's happening here, and that is why Merrick Garland rushed this particular case to the front of the line, and not like, for example, the range case and some other Second Amendment cases, which also could have served as a perfectly fine vehicle to talk about the application of Bruin going forward. So anyway, folks, hope you learned a little bit something here today. We're going to talk a lot more about Rahimi going forward. I did want to give you this initial impression of what's going on here and the startling statistics of how little the statute's used, and really does make you wonder why DOJ thought this was such an important case, because it's pretty clear it's really not in the grand scheme of things when it comes to public safety issues. It's very important to the extent it deals with the right to keep and bear arms and how it's interpreted by lower courts, because if this court were, for example, and I don't think it's going to happen, but if this court were to jettison the Bruin methodology and bring back tiers of scrutiny or balancing, it would be a tremendous win for the anti-gunners, and it would open up the floodgates for all sorts of more crazy gun control law, even more than what we're seeing today. So, all right, folks, if you haven't subscribed, please do so. We'll see you again soon here at the 4 Box of Diner.
Orders up. Table 2A.